You'll have to wait for some time till the matter is called. You'll have to wait for some time till the matter is called. Thereafter, we'll pass orders. आपको कहाँ चलेगी? अच्छा. Okay. There's an adjournment slip for item number 4 and 8. ये तो बोलो कोई कोई. Both sides are represented. An advance adjournment slip has been circulated in the matter. According to the matter stands adjourned today. List on. Give a date, fixed date. These are all old matters.
Item 1 for admission.
Yes. Which page is the opinion?
আমি লটে page 60 মিলত impin order
60.
60 and inquiry report milot page 47 inquiry report start from page 47.
Yes, he's right. The references of 61 to
66.
66 to 71.
Yes,
the
sir.
same.
And I am relying on judgment Santosh Kumar Miller. I have already submitted to this meeting.
And the
Other-
superintendent of police, he did not disagree with the
inquiry.
inquiry officer's comments. That's it.
哦，这个你这个，还出来过的，还出来没有了？所以我感觉very no good, this could not good.
2023 4 GLT. Yes. Thank you. where the reference was of the year 2004. At that time, Section 8(1) of the IMDT Act was invoked
Yes.
in 2004. Why it was registered in the under the foreigners case after a long time, we don't know. But the fact remains that at that point of time, the IMDT Act was there and the reference
Yes.
was made. In Section 8(1) of the IMDT Act, the question of stream is not there. He's a
Yes.
foreigner or not a foreigner. So now having the reference being made before the Foreigners Tribunal, it will be covered not by the 8(1) of the IMDT Act, but it will be covered by Section 2(1) of the Foreigners
Yes,
Order.
absolutely.
So there also, same thing, we don't have a stream. So even if you are prejudiced, you will have a right to go and what you call, contest the matter in accordance with the alternate reference.
Yes, my lord. Obliged.
Heard. Mr. A.M. Ahmed will counsel for the petitioner as well as so and so for the respondents. Bohu. By filing this petition under Article 226 of the Constitution of India, the petitioner has sealed the opinion dated 27/6/2018, page 60, passed by so and so in case number so and so, reference FT case number so and so, thereby declaring the petitioner to be a foreigner of both 25/3/1971. Next. But Mr. Ahmed, where is the copy of your notice?
And, yes. Of page 50,
50.
50, vernacular. Here also not mention the steam mill.
Correct.
Yes.
Then the opinion would be right.
Yes. No.
You see, you have been accused of being a foreigner. You have been accused to be a foreigner. The stream is not mentioned. That is in accordance with 2(1). So what is it? What is the illegality then? I was under the impression that the stream was mentioned and therefore you would be prejudiced. But the stream is not given.
And tribunal ought to have mentioned the steam mill
No,
as
not
per
required.
inquiry report.
Not required. That is clarified in Rukia Begum.
Hmm.
You prepare yourself, we'll take it up day after tomorrow. Because if this is the case, then the reference is correct. And the answer to the reference will also be correct. We'll give you an opportunity to be ready and answer and argue the matter. Take it up day after tomorrow. Next paragraph. Do not like this. Or both sides are represented.
Yeah, use করতে পারো।
It appears from the notice of the proceedings that the learned foreigners tribunal did not refer to any stream during which the petitioner had entered into the country as illegal migrant. Full stop. Moreover, the reference made by the Superintendent of Police, Morigaon, also does not disclose the year of stream during which the petitioner had entered into the country from specified territory. And in light of the decision of this court in the case of Rukia Begum Barbuya versus Union of India and others, 2023 within bracket 4 bracket close GLT 1208, what is inclined to the learned counsel for the petitioner prays for his granted time to address the court. Next para, list on 11/12/2025.
Item 2 for orders. Item 2.
Mr. Mehdi, we are not satisfied with the explanation of your delay. You took all the time in the world to file this appeal. You have taken all the time in the world which is available to file this appeal. 30 days is the prescribed period to file an appeal. Your 229 days delay, we don't find any explanation. Let's see. Yes. Hmm? Mr. Kadir, this case was ordered in view of the delay of 5 years. Here it is 200 days delay. If we accept your, the case cited by you, this Ramkumar Chaudhary, then I think it helps the Union of India. I understand, but this, no, but this grossly helps the applicant. The reason is that the order was of 26/7/2024. It was forwarded on 3/8/2024. Legal opinion was on 9/8/2024. That means all this happened within a month. So within 30 days, they have shown that they have done. What happened was, in Calcutta, somebody sat over it for 3 months. Only that much. Otherwise, you'll find that they going in a appropriate pace. No, but Mr. Vedhi, what is required by the order is only for you to take a decision. Why you want to file an appeal and burden this court? It has sent the matter back to you. That is the last operative part of the order. No, but we think he is be entitled to because he was selected after due service and that accident occurred in course of training. So he's not admitting. That can't be accepted as an admission. He's merely trying to convince the court that if you are hearing on delay, please don't enter into the merit. He's not conceding. On
One Mr. S.P. Gidi, Learned Counsel for the petitioner, and Mr. M.J. Kadir, Learned Counsel for the respondent number. Only respondent,
so respond.
sole respondent. This is an application filed under Section 5 of the Limitation Act for condoning the delay in preferring the writ appeal, condoning the delay of 229 days in preferring the writ appeal against the judgment and order dated
25/7/24.
25/7/2024, passed in writ petition 4606 of 2020. In the said application, the applicant has narrated the grounds for condoning the delay in paragraph 8 onwards.
Five.
5 onwards. 4 onwards, wherein the applicants have stated that after the judgment and order was delivered on 17/9/2020, delivered on 25/7/2024, it was forwarded to the Deputy Inspector General Law Directorate for further action on 3/8/2024, who had requested for a legal opinion on 9/8/2024, and a legal opinion was furnished on 15/8/2024. And the same was also forwarded to the Deputy Inspector General within bracket Law Directorate on 23/8/2024. Full stop. However, thereafter, it seems that it took time in forwarding the same to the Ministry of Law and Justice, Kolkata, for obtaining a final opinion for filing an appeal, and the report that was received from there. Full stop. It is reflected that on 17/9/2024, the Deputy Inspector General Law Directorate white signal directed the Ministry of Law and Justice, Kolkata, for taking a decision of filing an appeal. And the Ministry of Law and Justice, Kolkata, white UO, capital UO, dated 17/12/2024, opined that an appeal needs to be filed against the said impugned judgment and order. And the said UO was sent to the Deputy Inspector General Law Directorate for approval. And a final decision was taken to file an appeal on 20th of February 2025. And an appeal was prepared and was finally filed on 24/2/2025, causing a delay of 229 days. The learned counsel for the respondent had filed an affidavit in opposition, objecting to the condonation of delay, stating inter alia that the applicant had not explained 2 months delay after the Director General Law Directorate, Deputy Inspector General Law Directorate White Signal had sent the communication to the Ministry of Law, Kolkata. Mr. Medhi, S.K. Medhi, learned counsel for the applicant, has also argued on the merit of the case for condoning the delay. And Mr. M.J. Kadir had fairly submitted that the delay may be condoned for the ends of justice, not required. Merit of the case, no? We are satisfied with the grounds narrated by the applicant in the, Mr. S.K. Medhi had referred to the decisions cited by the Honorable Supreme Court of India in State of Assam. Supreme Court of India, in which decision you had given? You had given this, no? Mukul Kumar, Shivraj Singh, yes. Supreme Court, right? Supreme Court of India in delivered in Shivraj Singh versus Union of India in civil appeal number 5867 of 2015 in a judgment delivered by the Honorable Supreme Court. A civil appeal number 5867 of 2015, in which the Honorable Supreme Court has made a distinction. With what paragraph?
26 to 27.
26 to Acha. Wherein the Honorable Supreme Court has made a distinction between inordinate unexplained delay and explained delay. Full stop. He has also relied on Mukul Saikia. Who reported it? Shivraj Singh is reported. Reported in 2023 10 SCC 531. Civil appeal na lage. And what else? Okay. Mr. Medhi has also relied on the judgment delivered by the Guwahati High Court in IA within bracket civil 1243 of 2017 by the Honorable Division Bench. In which the Honorable Division Bench had condoned the delay of 397 days. Delay of 397 days? 397. See paragraph 27. On the ground that the delay has been properly explained. On the other hand, Mr. M.Z. Kadir has relied on the judgment of Honorable Supreme Court in State of Madhya Pradesh versus Ramkumar Chaudhary, reported in 2024 INSC 932. Wherein the Honorable Supreme Court has held that there would be no distinction between a private party or a state or Union of India when condoning delay. When the question of condoning delay is concerned. And the same analogy be applied for. And has further held that question of limitation is not merely a technical consideration. And in the facts of the said case, the Honorable Supreme Court has rejected Now, in the facts of the said case, the Honorable Supreme Court has refused to condone the delay and dismissed the appeal. You had given only this. In view of the consequence. Much better. In state of Madhya Pradesh versus Ram Kumar Chaudhary, the Honorable Supreme Court has held that the party seeking condonation has to explain the delay of 90 days by showing as to why the party was unable to institute the proceedings within that period of limitation. In the instant case, however, it is noticed that the department had initially taken proper steps in sending the copy of the judgment to the Deputy Inspector General, Law Directorate, as well as subsequent proceedings were done in time. However, later, when the opinion was sought for from the Ministry of Law and Justice, Kolkata, there was some delay. Full stop. As such, it is seen that within the period of the set period of 90 days, yeah, 30, it is here 30. The set period of 30 days within which the department has to explain the cause of delay as directed by the Honorable Supreme Court. The same has been done in the instant case. The only difference is that the later there was some delay, which is inevitable since different departments are involved. As such, we are of the opinion and we are satisfied with the grounds narrated by the applicant for the delay caused. And as such, condone the delay of 29 days for the ends of justice. The IA stands allowed. The registry shall register the appeal and list the same for admission. I is disposed of.
It will come because it will go and immediately come. We are giving you back the few citations you have given. We'll just keep that Ajay Chaudhary, Ramkumar Chaudhary, we are retaining. This you can get, send it back. Hmm.
One.
Yes, sir.
Supplementary item 15 for orders.
It would, I do. Have to go back and write the report. Report. Have to done this. Have to write the report. Yes.
तो कल देखा था मैं Easy.
Right.
कल
The nine lordship. And yes, lordship, and after filing of WS lordship, about 14 adjournment has been given by the tribunal lordship. WS was filed lordship on 15/11/2007. An opinion was passed on 21/4/2009. Legal ground my condition my. It's unable to pay it also my. Not on the merit of the secretary. Yes, you know. Yes, my other document is nothing, my left hand. Yes, ma'am. Yes, ma'am. Yes, ma'am. Unnati. That part, my lord, extremely sir, regarding my lord, written statement, there is nothing written, my lord. Like no explanation, no execute document was executed, my lord. Where the discuss, my lord, my approach some the petitioner is suffering, my lord, various details. My lord, kindly see the number of times he was admitted. Eye problem, my lord, heart problem, my lord, headache problem, my lord. And my lord, and respiratory problem also. My lord. So my humble submission, as the discuss, my lord, only consider of the condition. My lord. My lord, my lord, the petitioner, no document was executed, my.
After filing of subject.
When the was, police was arrested, my lord, that is. Yes, my lord. I have admitted that, but I have admitted, not denied, my lord. Admitted, my lord. My humble submission, these are the expert, you are the available documents the petitioner have, my. So at this stage, my lord, one opportunity may be given, my lord. Yes, my lord. Yes, my lord. In this honorable court, the coordinate base of, my lord, this expert is order, there is some, but kindly, my humble submission. At the interest of the justice, I have no weight in the case, man. I am admitted, man. But in the interest of the justice, my lord. I'm fairly submit, my lord. And 2000.
No, okay. No problem. Okay. Okay. Such kind of issues are discussed by this court, this honorable court also, Lord, in Abdul Mojid case, Lord. Abdul Mojid case, Lordship, that type of delay. Yes, Lordship. Mohammed Abdul Mojid, no, Lordship. Mohammed Mojid Ali, MD, MA, ZID, ALI. 2930 2025 WPC. Two MD, MA, ZID. Yes, Lordship. ALI Ali. 2930 2025 decided on 16/7/2025. Similar issue, Lordship, in this judgment. Similar issue, Lordship. It is similar, Lord.
Last, my lord, the consider of the federal pandit. The report already.
Ordering of the I. Ordering of the swelling. My head. Okay.
Item 3 for hearing.
The judgment and order is page 30, madam. Except 12. Father's name. Original name is Milord Afterali. Wrongly whispered my lord in the total is 1966 and 70 my lord Aftermali. Aftermali, this name is nickname. And the annexed this order, my lord, total list of 1966, my lord, annexed 5 page 8. Page 20 and six, my lord, serial number 305, my lord, Aftermali. He is his father's name. That times also my lord, wrongly. My lord, page 22. Like 1989 total is my lord. Petitioner's father's name, correct my lord, Asarali, mother's name is Silent Lecture. Other petitioner serial number is 233.
I'm sorry, please come again. Page number
Page 22, my lord.
22.
That's the
Yes.
serial number, my lord, petitioner name, my lord, Muhammad. First time recorded, my lord, 1989 actually.
This annexure 9 is just page 26, right? Yes, that is annexure 9. Next, page 28 is annexure 11. Where is annexure 10? Brother. DW2 was appeared. Number one, he has not been introduced in the written statement. In the written statement, his existence is not there. Second is that the DW2 does not say what is his relationship with you. He knows you. He knows you would mean that I know you and you know me. Nothing more. The reason is exhibit 4. Exhibit 4 is the NRC detail. Now here your grandfather name is mentioned as Irbin Ali. And for that you have no explanation. This is exhibit 30. Yes. Anything more? Which page? Please put on your speaker. Is it on? We are missing some of your voice.
It's not on.
Additional affidavit filed on my lord in the month of June, my lord, this year, my lord.
Affidavit filed in June. Yes.
My lord, here, my lord, page 38, my lord, serial number 4 is my lord petitioner name and her father's name also, my lord, Ator Ali, my lord. That is the copy of this
But
land,
this is the 2016 entry.
my lord.
This is an entry made in 2016. You have not said when your father died. In the written statement, not in your evidence, you have said that your father has died. Even in the additional affidavit, which you are showing us, you not state when when your father had died. And you know how brick by brick you are damaging the case. Come to page 15.
It's in the street petition, my lord.
Yes. 1-5. The name of the DW2 is, what is his
Royce
name?
Hawk, my lord.
What is the name of DW2?
Roysul Hawk, my lord.
Roisul, Roisul,
My lord,
Roisul Haq.
my lord.
You were showing us page 35, that is the additional affidavit. Come to page 36. Paragraph 3. Name of my father is Atar Ali. He has two sons who are alive, Riazul Haq and Ziaul Haq. Nothing to do with this Roisul Haq. Therefore, he does not come and say that you are my sister. She comes and says that I am the son of Atar Ali, but I know her. Atar Ali has one more son, who is not your brother. He merely knows you.
My lord, if your lordship permits me, matter maybe list after vacation, my lord, I try to
No.
convince your lordship, my lord, some mistake is there, my lord. That is, I am also confused, my lord.
No, we are convinced. Yes, Mr. Sharma.
No, nothing has been mentioned, Lord.
You see, till you don't make us read, you are good. After you make us read, then also you are good.
My lord, every document is showing that different name. That's why, my lord, I am also confused, my lord.
That's okay. Then
My lord, after vacation, any date, my lord.
safe thing is don't make us read. By the time you are showing us one page, we have read all the 3 pages. The difficulty. Yes.
Nothing has been mentioned about the WS as well as in evidence for the place of birth, place of birth, name of his parents, name of our grandparents, nothing has been mentioned and lordship. Each and every document lordship, there is a discrepancy lordship. Age discrepancy, name discrepancy, place discrepancy, all are there. The opinion lordship, everything has been discussed lordship. And also regarding to thing, after 1989 lawsuit, there is a huge gap. Nothing has been mentioned regarding the teach.
Please come again,
1970 to 1989 lawsuit. This is 1980, Village Cambodia.
just a moment. What about shifting? Please clarify.
Lordship, 1970 of Village Samburia, page 21. Vernacular. Then Lordship, next page.
This is, Samboria.
Samboria, and 1989 totalist lordship, next page, Lonka Gao. Here lordship, everything has been changed, lordship, father's name changing, lordship,
And this is,
age is
this is
changing,
89.
lordship, 89,
This is village.
Lonka
Gao.
Gao. And nothing has been mentioned, lordship, in the WS as well as in evidence, lordship. There is a huge discrepancy of age, lordship. Age and name, lordship.
ये तीनों देख ली
Yes.
So lordship, everything has been discussed, lordship, in the opinion, lordship. And lordship, death certificates are not proof, lordship. Gaubra's certificate and lordship. If we coming to the opinion, lordship, everything has been discussed, lordship, in the opinion.
Heard. Miss L. Wajida, Learned Counsel for the petitioner, and so for the respondents. Next, ma'am. by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 22/2/2017, page 29, passed by so-and-so in case number so-and-so, arising out of SP case number so-and-so, divide, declaring the petitioner as a foreigner post 25/3/1971 stream. Next one. The petitioner, upon receipt of a notice of the proceedings, appeared before the learned tribunal and filed a written statement, inter alia, stating that the case was not maintainable and there was no cause of action, and that the suit is barred by Indian Citizenship Act, 1955 and Foreigners Act, 1946. And the case against the petitioner was false, fabricated and vague, and that the investigating officer never visited the spot and did not verify the original documents. And case was filed to feed the grudge and enmity. The petitioner claimed that the name of her father was enlisted in the voters list of 1966 under 94 Lumding LAC. Lumding spelling is LUMDING. As well as first is 1966 and 1970. Make it both 1970. And the name of the petitioner was enlisted in the voters list of 1989 under 91 Hojai LAC. Here also make it 1989 and 2014 together. So the petitioner claims to have landed property covered by periodic patta number 24, tag number 354 of Samburia, SAMBORIA, Isam, KISSAM, and that the government Gambura of Dablong, DABLONG, has issued a certificate in favor of the petitioner. Accordingly, they to declare the petitioner as a citizen of India and not a foreign. Next, in support of her defense, the petitioner had examined herself as DW1. Wherein she has reiterated the statements made in the writ petition. And she had marked the following documents as exhibits, VIZ, full stop, voters list of 1966 within bracket, exhibit 1, voters list of 1970 within bracket, exhibit 2, both showing the name of the father of the petitioner as Akram Ali, AKRAM Ali. Stop. Voters list of 1989 within bracket, exhibit 3, containing her name. Voters list of 2015 within bracket, exhibit 4, and against wherein against her name there was a mark of inverted commas D, capital D, inverted comma closed, full stop. The certificate issued by the government Gambura of Samburia, SAMBORIA, village was exhibited as exhibit 5. She was a school student of Parasuram, Parasuram, Mozumdar, MSZUMDAR, Girls High School in Lanka in 1990. The school certificate was exhibited as exhibit 6. Stop. The secretary, Laskar, LASKAR, Pathar, PATHER, Gaon Panchayat has issued a certificate in favor of the petitioner within bracket exhibit 7. And the land related documents was exhibited as exhibit 8. Next. In support of a defense, the petitioner has also examined one Roisul, ROISUL, Hawk, HOQE, son of Ator, ATOR, Ator Ali, as DW2, who had claimed to be a citizen of India by birth, stating that further stating that the documents submitted and exhibited by the petitioner were correct and genuine, and he was conversant with the same, and stated that the petitioner was a bona fide citizen of India by birth, having sufficient documents in support of her Indian nationality. Next. Howard, on a perusal of the tribunal's records, it appears that the petitioner was asked questions by the learned tribunal, and such examination is recorded in the back page of page 2 and 3 of the evidence on affidavit filed by the petitioner as DW1. Wherein the learned tribunal had recorded the documents exhibited as follows, VIZ, it's quite serially here, 1, 2, 3, 4. Certified copies of voters list of 1966 within bracket exhibit 1. Certified copies of voter list of 1970 within bracket exhibit 2. Showing the name of the father of the petitioner as Akram Ali, son of Ako, AAKO, Ako Mia, MIYAN, and mother's name as Sundar, SUNDAR, next word Nesa, NESA, under 94 number, Lamding LSE. Certified copy of voter list of 1989 within the bracket exhibit 3. Downloaded copy of NRC details within bracket exhibit 4. Showing the name of the grandfather of the petitioner as Irvin, IRBIN, Irvin Ali. School certificate within bracket exhibit 5. Showing the name of the father of the petitioner is Akhtar, AKTAR, Akhtar Ali. Copy of Jamabandi within bracket exhibit 6. Comma by which mutation was granted on 27/1996. Land revenue paying receipt within bracket exhibit 7 and exhibit 8. Next, certificate issued by the government Gaubura within bracket exhibit 9, and certificate issued by the secretary, comma, Laskar Pathar, LASKAR PATHAR, Gaon Panchayat within bracket exhibit 10. Photo identity card of the petitioner within bracket exhibit 11. Petitioner's affidavit sworn in support of explaining a father's name within bracket exhibit 12, comma, and next is Kabin Nama, KABIN Nama, NAMA, one word, of marriage of the petitioner held on 11/3/1991 within bracket exhibit 13. Next, on considerations of the contents of the documents, comma, the learned tribunal found that the name of the father of the petitioner was recorded in exhibit 1 and 2 as Akram Ali, AKROM, Akram Ali, son of Ako, AAKO, Nia, and mother's name as Sundar Nessa, SUNDAR, next but Nessa, NESSA, instead of the instead of Ator Ali, ATTOR, Ator Ali, his father, and Akumia, AKU, Akumia, MIYAN, and mother's name as and
Fine.
mother's name as Sundar Nasa, SUNDAR, Nasa, instead of Foyrun, FOYRUN, Foyrun Nasa, as respond contrary to the pleadings of the petitioner. Similarly, discrepancy of name and age was noticed in the voters list of 1989 within bracket exhibit 3. In connection with this exhibit 3, the learned tribunal had recorded that the petitioner did not mention anywhere regarding shifting of village from Samburia, SAMBARIA, to Lanka Gaon, LANKA, next word Gaon, GAON, within bracket east part bracket code. Though the download copy of the order was not a valid document evidence, the learned tribunal perused the contents of the said exhibit 4 only to mention in the impugn opinion that as per the petitioner, the name of her grandfather was Aku, Aaku, Miya, Miyan. But in the said document, in the said exhibit 4, it was mentioned as Irvin, Irvin, Arvin Ali. Full stop. Even there was a discrepancy in the name of the father was noted in school certificate within packet exhibit 5, where instead of Athor Ali, ATTOR, Athor Ali, the name of the father is of the petitioner is stated as Akhtar, AKTAR, Akhtar Ali. In Jamabandi, this packet exhibit 6, was discarded on the ground that the mutation was granted by order dated 30/7/1996. And therefore it was of recent origin. Accordingly, it was also at that exhibit 7 and 8 in the land revenue PPC, not held the petitioner. The certificates issued by the Gaon Bura and the secretary of the concerned Gaon Panchayat within bracket exhibit 9 and 10. Exhibit 9 and exhibit 10 were discarded on the ground that those documents were not proved in accordance with law. This would mean that the author of the said certificates were not examined. The photo identity card within bracket exhibit 11 was held not sufficient to establish linkage with the documents of pre-dash cut dash off OFF of date 25/3/1971. Therefore, it was not a proof for citizenship status of the petitioner. The affidavit with the packet exhibit 12 was discarded as the said affidavit had no evidentiary value. The Kabinnama within packet exhibit 13 was also discarded as it discloses marriage of the petitioner on 11/3/1991, which cannot be used for engage of the petitioner unless the document is of pre-cutoff date. Resulted in comma the petitioner that we have found no but she could not prove a linkage with the projected parents and grandparents. We'll continue after lunch. And refer to the stand taken in the writ petition as well as in the additional affidavit filed on 25/6/2025.
That's done. Done. All right.
এগুলা additional affidavit আছে দুটা কপি হাতে রেখে দিয়েছে সেকেন্ড জাজ কপি নাই পিছনে রাখতে বলবি পিছনে রাখ
He has two sons. All right.
submitted that the discrepancies in the name of the father of the petitioner was father and grandfather of the petitioner was not a good reason for the learned tribunal to discard the evidence of the petitioner. So it was submitted that the petitioner has explained the discrepancy in the name by exhibiting an affidavit sworn on 22/12/2015. Moreover, it was submitted that the name of the petitioner was mutated in respect of a land which belonged to her father. And that the PAN card of the petitioner also disclosed the correct name of his father, of her father. Accordingly, command is submitted. The impugn opinion is not sustainable, and the same is liable to be set aside. Next. Per contract, the learned standing counsel for the FT and border matters has submitted that though there is uniformity in the name of the petitioner's father and grandfather in the electoral roll of 1966 and 1970, but thereafter the next electoral roll is of the year 1989, where there is a change of the village of the father of the petitioner. And moreover, there is also a distinctive change in the name of the father and grandfather of the petitioner. As the village, I said village and
As well as ages also.
Huh?
Ages also sending doctor. Age also sending.
moreover, it is submitted that there is some discrepancy in the age.
Muslim.
Accordingly, by referring to the content, the contents of the NRC and the disclosures made in the additional affidavit by the petition, filed by the petitioner, the learned counsel. Learned standing counsel for the FP matters has submitted that there's no infirmity in the imperial opinion. Next part. In this case, the additional affidavit filed by the petitioner on 25/6/2025, instead of coming to the aid of the petitioner, is found to have demolished the case of the petitioner. Full stop. In paragraph 3 of the additional affidavit, the petitioner has stated on oath that his father has two sons, who are alive. Her father had two sons who are alive, and disclosed their names as Rezaul, Rezaul, Haq, Haque, and Ziaul Haq, Ziaul, Haque. Stop. However, though the DW2 has though the DW2 has disclosed his name as Roisul, Roisul, Haq, Hoque, son of Ator Ali, Atur, Ator Ali, the said DW2 has not made a positive statement that he is the brother of the petitioner. Stop. Moreover, as per paragraph 3 of the said additional affidavit, there is no reference to the DW2 as the son of Ator Ali. Stop. Therefore, in the absence of any disclosure in the affidavit, in the evidence on affidavit of DW2, disclosing his relationship with the petitioner, in view of this statement made in paragraph 3 of the said evidence on affidavit of DW2, that he knows the petitioner of who knows the petitioner, leads to no other conclusion that he is nowhere related to the petitioner. Therefore, as DW2 is not stated to be the brother of the petitioner, his evidence is of no value, being an unrelated person. Full stop. In the said paragraph 3 of the additional affidavit, the petitioner has stated on oath that his father had 4 daughters who are alive, and their names are disclosed as Salma Begum, Salma Begum, Muslima Begum, Muslima, and Rohima, Rhima, Rahima Begum, and Hassel. And no, stop. However, in the electoral roll of 1989, 89, within bracket exhibit 3, the name of the three daughters of the father of the petitioner are Halima, 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 comma, Asma, Asma, and Salma, Salma. Full stop. Therefore, there appears to be a mismatch in the names of the daughters of his father, of her father, comma, disclosed in paragraph 3 with the contents of the electoral roll of 1989. Stop. We also take note of the fact that in the voters list of 1989, within bracket exhibit 3, comma, the names of the two brothers of the petitioner are not disclosed. Stop. In fact, there is no electoral roll or any other document disclosing the name of the said two brothers of the petitioner. Or the existence of sisters, namely Muslima Begum and Rahima Begum. Next one. Therefore, comma, the statements made in the additional affidavit dislodge the petitioner from the very case which was set up by filing the written statement. Next one. Moreover, comma, it is surprising to note. No, we also find force in the submissions of the learned standing counsel for the FP matters that as per the contents of Exhibit 4, comma, which is a downloaded copy of the father of the petitioner, comma, the name of the grandfather is not disclosed as Akku Mia, Aaku Mia. Or Aklu Mia, Aklo Mia, or Ako Ako Mia, which are the names of the grandfather of the petitioner as disclosed in the exhibit, in the affidavit within bracket exhibit 12, comma, but the name of the grandfather of the petitioner is recorded in exhibit 4 as Irbin, Irbin, Irbin Ali. Similarly, in exhibit 5, which is a school certificate, comma, the name of the father of the petitioner is recorded as Akhtar, Aktar, Akhtar Ali, and not Ator Ali, Attor, Ator Ali. Next paragraph. In respect of the entries made in the Jamabandi within bracket exhibit 6, comma, the entries are made on 37/1996 and therefore this is not a document of 3/25/1971. Moreover, the link certificates which were issued by the government Gaambura and the secretary of the Laskar Pathar, LASKAR Gaon Panchayat, within bracket Exhibit 9 and Exhibit 10, are not proved by the authors. The Kabirnama within bracket Exhibit 13 discloses marriage of the petitioner on 11th May 1991 has also not been proved by calling for the Qazi or the registrar of, not Qazi, the registrar of Muslim marriages, which is a requirement under the Assam Muslim Mr. Dhamik, that Assam Muslim marriage. Which is the requirement of Rule 51 of the Assam Muslim MOSLEM, Muslim Marriages and Divorces Registration Rules, 1935, requiring that if the production of a register in any court is required, it shall be produced by the Muslim MOSLEM, Muslim registrar or other officer whom district registrar may depute for the purpose. Full stop. Resultantly, the land revenue paid records within bracket Exhibit 7 and Exhibit 8 does not help the petitioner in any manner. Similarly, in view of the discrepancy of the name of the father and grandfather of the petitioner, the court is of the considered opinion that the opinion of the impugned opinion dated 22/2/2017 passed by so and so page 29 is not found to be vitiated any grounds whatsoever. Next, accordingly, the challenge to the present, the challenge to the said opinion fails. Stop. Consequently, the petition stands dismissed, leaving the parties to bear their own cost. Next, the registry shall return back the records of the tribunal back, along with a copy of this order to be made a part of record by the said learned tribunal. Next, consequences of the said impugned opinion shall follow.
Item 5 for hearing.
Yes, Mr. Atia, how's your health? Good. My lord. Yes.
What are the case number of E? Can we? I don't mind it, can we? Go through that. We go through. Go through the adjustment. So there is no contradiction of the document produced by the petitioner in their support matter. Can we see is your statement has been filed by the petitioner and
Just a
evidence
moment,
also.
just a moment. Yes.
I don't. Tribunal, my lord. In the judgment, my lord, stated that the combined evidence has been submitted, my lord. And my lord, Exhibit 1, the certificate copy of the voter list of 1954, in accordance to the opposite party PW1, the name stipulated therein is the name of the father of opposite party, Muhammad Amla Khatun, and the grandfather of the other opposite party of the connected case. In the statement in cross, the state opposite party Amla Khatun is also the mother of the opposite party, her son and daughter. She has deposed that her father, namely Ilumia, had died last 16, 17 years ago at the age of 19. The first week from the first statement in cross, the same opposite party does confess that her father had expired in between 1999 to 2000, that is 16, 17 years ago, from the month of December 2016. The opposite party said his father's age at the time of his death, that is the 1999 to 2000, was 90 years, as disclosed by the opposite party. Amila, in that way, his year of birth would fall sometime in the year of 1990 or 1910, and in the year of 1954, his age was to have 44 or 45 years instead of 30 years, as reflected in Exhibit 1. There cannot be a variation of 14, 15 years of age of the opposite party. State father in Exhibit 1 in the light of the statement in cross. The age discrepancies. But my lord, in the voter list, it is clearly stated that the passport, the date of birth, also clearly stated in and this cannot be a ground for declare a person, my lord, to be a foreigner. And secondly, my lord, whatever to be matters is status, my lord, in the voter list 1954, my lord, the petitioner number was mother, petitioner mother thing was not there. The certificate copy, my lord, we obtained by the Kinumia himself. It might have been, my lord, her name in the voter list, my lord, really, but only father of the petition number one obtained the certificate copy in his name. My lord. And this is the main ground to declare the petitioner as foreigners. The other hand, my lord, kindly peruse, my lord, page 63, last paragraph, my lord, can you see? Page 63. Not only to mention that as stipulated in the inquiry report, the IO has stated in from 3 finding an inquiry report of the IO that the opposite party, Muhammad Amala Khatun, has produced as much as 17 numbers of documents in support of her claim of Indian citizenship. However, those documents are not produced with the joint evidence of OP, PW1, and as such, this tribunal has hardly any chance of access to those documents. Probably the IO, as appears from his report, had tried to enter into a holy nexus with the opposite party, Dr. Amala Khatun, although he could not succeed. This is the ground, my lord, to declare the petitioner as to be a foreigner. And his documents, my lord, he submitted 11 document voter list since 1954, his father, and thereafter her father, and thereafter, my lord, the voter list of the petitioners, my lord, genuine voter list of the petitioners. The tribunal, my lord, failed to, my lord, appreciate the voter list or he reject the claim of the petitioner. Author of petition number one was born in Dhaka, my lord, undivided India, my lord. Yeah. Then after partition, he remained in this village, my lord, and he obtained passport in the year of 1961 in his name, along with his child, the petition number one, Amila. Slight discrepancies in the name and age is there. Otherwise, my lord, there is no any.
Mr. Sharma,
Yes, Lord.
please see what it is 17 document. I'm not readily getting it.
Page number. Okay.
Hmm?
Healthcare.
Something wrong.
Page 17, Lord. This is interrogation report. Interrogation report, Lord.
No. That part which Mr. Athia read, that 17 documents were produced before during the inquiry, which were not produced.
No, police alone can refer.
64.
Page 6.
So where are these 17 documents? That means that the police reference must have 17 documents.
Yes, yes, sir.
Now, where is that? See the record of Amela Khatun. All 6, 7 records are there. Look at the records of Amela Khatun.
Yes, sir. Yes, sir. Yeah.
But Mr. Sharma,
Look.
let us say that a lawyer has annexed 20 annexures to a writ petition. While arguing the case before us, he refers to only 2 documents, he does not refer to 18. Can I dismiss the writ petition only because of that?
Hmm.
That you have annexed 20 documents, but only urged only 2 documents, therefore I dismiss your writ petition? No.
Okay. Okay.
And you see, the tribunal writes that because of 17 documents are not produced, the IO is in holy nexus with the with so and so.
Without having
This is without hearing that IO. An observation is made.
Yes, sir.
Please send back the record.
Yes, sir.
Oh, see.
Yes, sir. Yes. Page number. Hello. Facebook now मतलब हो जाएगी कभी नौगम हो जाएगी under India Yamuna constituency and sometime it was मतलब हो जाए constituency then again Yamuna constituency now मतलब Binna Gandhi constituency. Yes, earlier it was under Murajar PS. Now it's under Daboka PS.
Lordship,
Six, page 36. Page 36. Necessary minority. While an additional affidavit the complete document. Well. Well, can you give me 5 days time, because they have to sign the affidavit one.
Item 6 for hearing.
Lordship, here in item 6, Lordship, BC Das was here, Lordship, but due to chest pain, Lordship, he left the court, Lordship. Yeah. এই কোডগুলো কখন BC Das স্যার কোর্ট মাস্টার বলছেন দাদা এই BC Das স্যার বলছেন
Item 7 for hearing.
Info order. Place Milord 67. Info order at best. Upper department of the OP activity document of activity 1 is the method of the found it is or the report return detected. Activity 2 is certificate of cabinet of found it from how the report detected. Activity is method to the in the medium of the PKPS to be not legal for the purpose of the case is possible. It's but activity 4 is the total list of activity 5. It appears the claim to them and to be others accepted. Activity 5 to get another correct, but accept for the matter of but it appears the claim of them and to be others accepted. Activity 6 is also extract of 1974 appeared to members of this for the specific 7-1 and 7-2 is concurred in the name of office. After each of the copper and cathode mentioned document is transferred back the linkage of the not the with the claim of the resource of the OP is liable to declare property. However, not going to merit of the case number. I want to go on the LBU report first. LBU report as case 23. Here, my lord, only the inquiry officer filters only the column number 1, 2, and 3. Other remaining rest columns are not filled up. That means they have not conducted verification properly. In this regard, I have carried on document number 2022 for TLT case 102. Amina Khatum Negi. This issue was settled Lordship in WPC 245 of 2019 Lordship. Amina Khatun's case was distinguished Lordship. The Amina Khatun case, para 6 and 8 reporting. Para 6, 7, 8, and 14. Please, Mary.
the ERO report, they have filled up. Date of birth, my lord, column number 4, 1967. Petitioner was born in the year of 1981. That means that they have not, inquiry, they have not conducted for parliament. Para 6. Yes. In the ERO report, which is based on the LPO report, some doubt has been expressed about the sufficiency of the affected person. However, when we see the LPO report, we have noticed that the entire format is blank except the name mentioned as a wife of Ismail as regards the various other particulars equal to be filled up. There is nothing mentioned except the word absent on the top of the form. If the basis of the doubt on the citizenship of the person is based on LPO report, we have of the view that since the LPO report is devoid of any particular or any finding or for the matter any remark or observation, the said reference cannot be said to have been made after proper application. That was not furnished, my lord, but judgment says PW has pros at examination.
Tara, it is not a fact that exhibit 1 is duly proved. Uh, it is not a fact that if contract certificate is uh, relevant. Uh, yeah. My father had no other landed property. It is not a fact that I am an Indian national.
Yeah. We in fact always express our thanks to lawyers who don't read the LCR. It makes our works easier. Everybody thinks that this is something which lower court will see. End of the matter, you don't have anything. We go by this statement only. But we'll take care of your submissions on this EVO.
That was distinguished Lordship in two, that was distinguished Lordship in 245 of 2019 Lordship. WBC 245 of 2019.
Name of the parties,
SHUKURJAN, Chukurjan Nesa, NESSA, alias,
no, even there's a order by me,
yes, Lordship.
which is that.
Amina Khatun was distinguished Lordship in this.
Hmm?
Amina Khatun was distinguished in this.
No,
That
in fact, I have also authored an order,
Yes, Lordship.
which is that one.
Yes, this one Lordship.
Let's pass it on.
Para 20 specifically stated.
Your name?
Islam. Islam.
A Islam.
Islam.
K.
Other submission I want to submit in written.
Mr. A Islam, the counsel for the petitioner, as well as so-and-so for the respondents. Next, filing this petition on Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 19/5/2018, page 67, passed by so-and-so in case number so-and-so, reference IMDD case number so-and-so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next. On a receipt of the notice of the proceedings, the petitioner had appeared before the said learned tribunal and filed a written statement, enclosing thereto 10 documents in support of her defense. First off, it was stated that the petitioner was born and brought up at village Jaldoba, JALDOBA, Part 1, under Bagribari, 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 district Pokrajhar, and was married to one Fajar Ali of village Jaldova, Part 2, Roman 2. Full stop. The name of the petitioner is recorded in the VCDC certificate issued on 4/2/2018, wherein her father's name is Habibur Rahman, Habibar, Habibur Rahman. Her name is also recorded in the bank passbook it was stated that the name of the father of the petitioner is recorded in the NRC of 1966, showing voter detail. For which reference is also made to the certified copy of the voters list. Of 1966 and 1970. Full stop. The name of the petitioner appears in the voters list of 1997. And the name of the father of the petitioner appears in the voters list of 1985. Stop. It has been stated that the father of the petitioner, the grandfather of the petitioner is Hazrat Ali, Hajarat, Hazrat Ali is a citizen of India by birth. And his name is recorded in the voters list of 1966. Full stop. It is, the petitioner has clarified that her name is Haimala, Khaimala, Haimala Bibi, but in some documents, her name is recorded as Haimala, Khyamala, Haimala Bibi. Full stop. In support of her defense, the petitioner has filed her evidence on affidavit wherein by reiterating the statements made in the written statement, the following documents were exhibited. Link certificate within bracket exhibit 1. Link certificate, give a date, 13/7/2017. VCDC certificate dated 4/2/2018 within bracket exhibit 2. Bank passbook of Assam Gramin Vikash Bank within bracket exhibit 3. Voters list of nineteen 85. Disclosing this, they're disclosing the names of Habibur Rahman, which page is that? एक हालत में एक हालत में how will you spell it? Page 44? Yes, what is the name? Hajrat.
Habibur Rahman, my lord.
Next name, father's name.
Hazrat. Hazrat.
That is Ekar, Hajrat.
No, my lord. Jaw.
That is jaw only. It's a part of jaw. Okay. Hajrat. Hazrat. Hazrat. And this is Mori. This is not Mayuri.
Mauri.
Mori.
Mauri.
Mouri. Mori Bibi. Within bracket, translated in the English version as Mayuri, Mayuri, Mayuri Bibi, by the petitioner, practical husband, make it wife of Habibar, Habibar. Certified copy of electoral roll of 1966 within packet exhibit 5 containing the name of Habibur Rahman, son of Hazrat Ali. Electoral roll of 1970 within bracket exhibit 6 containing the name of Habibur Rahman, son of Hazrat. Petitioner has also exhibited the PAN card within bracket exhibit 7. PAN card of one Hiran Bala Ray, HIRAN, Hiran Bala BAN, RAY, within bracket exhibit 7. Within bracket 2, Roman 2. Hiran Bala Ray, son, sorry, daughter of Gandu, 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 Ray, RAY. as per the learned tribunal, merely referred to the exhibited documents and remarked that exhibit 1 and 2 were rejected. So the exhibit 3 was discarded and exhibit 4, 5, and 6 were accepted. And opined that the lineage of the petitioner was not established with the claimed father. So accordingly, the petitioner was declared to be a foreigner. Next. The learned counsel for the petitioner has made his oral submissions and has filed a written note of argument, stating therein that the vital columns of the verification officer's report has been left blank. And accordingly, it has been stated that the report of the ERO, within bracket, electoral registration officer, bracket, report dated 16/10/1997, was without, relying on the LVO report without any verification, has vitiated the proceedings. What is this paragraph 4, column 7? Where is that? Page number?
ERO report.
Wait, paragraph 4. Don't know what you are referring to. Paragraph 4 of your written argument.
Written argument. Perhaps it is LGO report in the serial number 7 mine. If the serial number and part number of the concerned electoral roll together with constituency number. Sorry.
So in your writ petition, which is which page?
There are 4 perhaps page 31 in the repetition mine.
31.
31. Serial number 7 Melo. Does the person's name appears in the electoral roll prepared prior to 25 day of March 1971? If so, details. Am I right, Melo?
stated that as the petition was born on 7/8/1981, comma, column number 7. Of the form for reference as to whether the name of the person appears in the electoral roll prepared prior to 25/3/1971 is a mockery in the name of reference. It is also stated that the notice dated 27/12/2017 issued by the tribunal is contrary to the LVO report, which is not clearly stated where and when the petitioner came into India. It has also been stated that the reference was made on 29/7/1998 by the Superintendent of Police, Dhubri, who had no jurisdiction under the Foreigners Act, 1946, or Foreigners within bracket Tribunal Act Order, 1964. As the petitioner was a resident of under Kokrasa district, it's also been stated that the written statement and the electoral roll of 1966, 1970, 1985, 1997, bank passbook, and the link certificate have not been considered by the tribunal. And that in the cross-examination, the evidence of PW1 could not be demolished. And moreover, there was no discussion regarding the exhibited documents. Accordingly, stated that the opinion is bad in law and matters liable to be remanded. Next. The per contract, the Laret standing counsel for the border and FP matters by referring to the decision of this court in the case of Shukur Jan, SHUKURJAN, Nessa, alias Sukur Jan, SUKURJAN, versus the Union of India and others, WPC 245 of 2019, decided on 28/2/2025. I submitted that the present reference being made at the instance of the electoral registration officer, would have to be examined in the light of the reference which was made under the erstwhile illegal migrants within bracket determination by tribunals bracket Act, 1983. And there's that those references were required to be examined by the illegal migrants within bracket determination by determination bracket close tribunals. To stop, however, on the said tribunals being declared unconstitutional by the Supreme Court of India in the case of Sarbananda Sonowal versus Union of India and others, comma, within bracket 2005, bracket close 5 SCC 665. Submitted that the submissions made by the learned counsel for the petitioner would not help the petitioner in any manner. Next paragraph. Considered the submissions, including the written notes of submission by the petitioner and the materials available in the writ petition as well as the tribunal's records. We'll pass the orders in chambers. I have to rise for the single bench. We'll be releasing the order today. It will be dismissed. The dismissal will be on the ground of admission by the petitioner that he is not a Indian. He admits that she is not an Indian citizen.